Good afternoon, Dr. Chapman.
Good afternoon, sir.
Would you introduce yourself to the court and identify your profession?
Yes, my name is Dr. Christopher Chapman, C-H-A-P-M-A-N. My business address is 16 South Avenue West, Cranford, New Jersey, 07016. I am the founding director of the criminal justice program for the City University of New York at Kingsborough. I'm also the executive director of the National Excessive Force Institute. And I'm also an associate professor of criminal justice within the City University of New York.
Let me ask you about the National Excessive Force Institute. What is it?
It's a 501c3 nonprofit, nonpartisan, non-political organization that assesses the reasonableness of police actions throughout the United States, specifically in the United States. We conduct community forums where we help bridge the knowledge and information from citizens as to what the job of a police officer is, why police officers engage in certain behaviors or certain activities. And then at the other side, we conduct research of municipalities or jurisdictions to get the sense of the citizens' perceptions of law enforcement. And then we bring those two bodies together where we have real conversations about some of the problems as perceived by citizens throughout the United States, as well as some of the fears that police officers have of working in certain communities. In addition, we got approval for, have a peer-reviewed journal where we have professionals and academics from about 17 universities across the United States that are on the editorial board, where we assess writings of scholars or practitioners dealing specifically with police use of force in the United States. Does this sheet go up?
I don't know.
I'm sorry.
Is it too low or, okay, we'll take a look at it. See if that's better.
Oh, much
Better, okay,
Oh,
good.
Much better. Thank you. What did I say? Oh, so we have academic and scholars from several universities throughout the United States that serve as peer reviewers of writings for publication. We do assessments of police departments for them on a variety of different areas, from their training to their use of force, to their relationships with minority communities, and we provide, and that's about it.
Yeah, I think you said earlier that it's nonpartisan. Is that right?
Yes.
Okay. And what does that mean in terms of how you approach the mission of the Institute?
Right. So as hard as it is not to bring your life experiences and your baggage with you when you make an assessment of things, regardless if you're a Republican, if you're a Democrat, or if you're independent, well, you can have a party affiliation, but the National Excessive Force Institute, we're nonpartisan, meaning that we don't support any political candidates or any positions. Our activities and our opinions are based on data.
And you said that you assess, among other things, use of force incidents?
Yes, we assess use of force incidents, whether or not a citizen's using force against a police officer during an encounter, or whether a police officer is using force against a citizen.
Are you charging for your services in this case?
No, I'm not.
And why is that?
Well, so the board members of the National Excessive Force Institute, we thought about this case, and actually it was a suggestion from my students back at the university, where we bring real life situations into the classroom, and using the open source data that was on the internet from the FBI. So I had students at Kingsborough Community College in Brooklyn, New York, looking at things, and we got their opinions. And then this is during classroom time. And then after we give them certain instructions as to what a police officer is allowed to do and why they do certain things, we looked at whether or not the students' opinions would change. And then the students said one of our requirements for graduation is a civic engagement requirement. And they said, well, are you charging for this? I said, well, my time is very valuable. And they said, well, what do you normally charge? So I told them, I said, I usually charge about $400 an hour. And they said, well, do you give back? And I said, yeah. And we talked about this organization that we have, and the members of the group, we decided that we would do this case pro bono.
Let's talk about your educational background, and then we'll talk about your professional background.
Sure.
Your educational background, starting with your undergraduate degree.
Right. So I have an associate's degree from Union County College, which is located in Cranford, New Jersey, with a concentration in criminal justice. I have a bachelor's degree from New Jersey City University, which is located in Jersey City, New Jersey, with a concentration in criminal justice. I have a master's degree in criminal justice from Boston University, I should say concentration in criminal justice, located in Boston, Massachusetts. And I have a PhD from North Central University with a concentration in criminal justice.
Then let's talk about your professional background. Did you start, well, let me ask you this. Have you been a police officer working for a police agency?
Yes, so I started as a police officer in the township of Cranford in 1988.
And how long were you employed with them?
So I was employed by the township of Cranford for 20 years. And when I say 20 years, I say 20 years of real world policing experience, because simply a number of years does not mean you have certain experiences or skill sets. So I was employed by the township of Cranford as a police officer for 20 years, but within that time, I was lent out to various other law enforcement organizations. So after I graduated from the police academy, I went back to the police academy as a police academy instructor. I then went back to the Cranford Police Department, where I was a patrolman. I then went back, then I was on loan to what we consider like the state, we call it the prosecutor's office. So it's like the district attorney's office, where I, from the district attorney's office, was lent to approximately 15 other law enforcement organizations within the state of New Jersey, where I would either be conducting training, use of force training, or specifically engaging in narcotics investigations. And then at one point, again, I was loaned to the International Police Chiefs Association, where I had somewhat of a fellowship where I would travel overseas and I would teach use of force in different countries such as Argentina, Korea, France. Then I would go back to the Cranford Police Department. Then I was promoted to a police sergeant in charge of a patrol unit, where obviously making sure the police officers did what they were supposed to do when they're patrolling. I then became an emergency services coordinator, where my responsibility was for the training of the department, as for our use of force training biannually, meaning the police officers would have to go through use of force training twice a year. And then again, I would go back to the prosecutor's office, where I would train at our police academies. Our police academies are they're run by the New Jersey Police Training Association, and each county has their own police academy. So I would write training programs for other use of force instructors, and they would take those programs back to their individual county police academies, and they would incorporate those use of force training programs. I then would be lent out to organizations like the DEA or the FBI, or specifically U.S. Department of Homeland Security. And then again, I would conduct training for the Department of Homeland Security within our SAC offices. as well as I would participate in investigations while with the U.S. Department of Homeland Security. I conducted financial crimes. I was assigned to a financial crimes unit. Then there was talk that I was coming back to the Cranford Police Department, so it was suggested that I stay with the Department of Homeland Security, but I aged out, meaning I met the maximum age for working for the U.S. Department of Homeland Security. So there was a fix. I took the test, and then I was sworn in to the U.S. Department of Homeland Security. And then after the whole process was done, and again, still doing what I was previously doing, I was told I was going to have to go to West Virginia, and it wasn't ripe for me and my family at the time. So I left the U.S. Department of Homeland Security, or separated, in 2011. Since that time, and during that time as well, the State Department and other organizations would ask me to conduct assessments or to provide training on their behalf to different jurisdictions or different countries. An example is that the State Department set up a mandatory training for all police chiefs in Mexico that had to attend, where I instructed on best practices in use of force, as well as best practices in internal affairs investigations, which, as Your Honor knows, is just simply, what are the best practices to assess the difference between an officer, what practices should a law enforcement agency use when they're assessing the behavior of a police officer, and then what practices should they use when they're investigating a police officer, and if there is a connection, there's a disconnect, whereas whether or not, if a police officer used a particular tactic, where there may have been like a better tactic or a new tactic, but the officer didn't use that tactic, they used a good tactic or a reasonable tactic, should the internal affairs investigation officers hold that against the officer? So I do a lot of training. In addition to that, prior to the National Excessive Force Institute blossoming, I should say, or being born, there was another organization which is still active, and I'm still a member of. There's a couple of them, and one of them is Black Cops Against Police Brutality, where we did pretty much the same thing, where we would go into communities and we would teach citizens or inform citizens as to, one, what their rights are, as well as how do you actually assess a police officer's use of force, or how do you assess a police officer's actions in a given situation. Not just what your feelings are, what your gut tells you, what are the objective factors that you look at. Another organization, and then I'll stop. Another organization is Blacks and Jews in Conversation. My university is in Brooklyn, New York, which is a predominantly, the section where I'm in is predominantly a Jewish neighborhood, but the majority of students that go to our university or our school and at campus are Black and brown students. And their perceptions of interactions with the police and with the court systems is different than what a white person's interactions are, whether it's real or imaginary. So the Black Cops Against Police Brutality is made up of academics. In New York, we call them Supreme Court justices. So there's 4 or 5 Supreme Court justices that are part of the group, as well as we bring in police commissioners, police chiefs from the areas where we're doing these civic engagement activities. And people are able to come into a room. We have a discussion, we talk about real issues, we give them hypothetical situations as well as real issues, and then they're able to ask, a police officer, am I allowed to do this? And the police officer may say, no, you're not allowed to do this. But again, the Supreme Court justice that's within Brooklyn is sitting there and says, well, the police officer may arrest you for that, but when you come before me, I'm going to throw it out. So it's really a great opportunity for citizens to really be able to question police actions and to know what their actual rights are, and then to have a basis for having an opinion.
Okay. So would it be a fair statement to say that you've had real-world experience on the street as a police officer?
Yes.
And you have trained in all of the various agencies and departments and countries that you've talked about on use of force?
Yes, sir.
Okay. And you are also an academic?
I am an academic.
You earlier told us that you're the director of the criminal justice program at City University of New York at Kingsborough. Is that right?
Well, no longer the director. There's no director of the program, the founding director.
Okay, founding director. And when did you become the founding director?
I'm just going to refer to my CV here. (2009).
And are you still employed at the City University of New York at Kingsborough?
City University of New York at Kingsborough. Yes, I'm an associate professor, and I teach and unofficially still direct the program, which I don't receive compensation for.
Do you also publish?
Yes, I publish as well.
What type of publications have you been involved in?
So my area of, I'm a criminologist, I'm a critical criminologist, and I study why do police officers engage in criminal or deviant behavior. The areas that I research and write on specifically deal with a police officer's use of force. And not just a general police officer's use of force. I started off doing police officers' use of force. Why do they use force? Why do they use force in one community more than other communities? And then I started looking at why do police officers use force within black and brown communities? And I say black and brown instead of saying African American and Hispanic because it's black and brown. Because sometimes you can't tell what the person is, it's just a perception. So I do research as to trying to look at attributes of individual officers to determine if I can predict which officer is going to use force, unreasonable force or excessive force within particular communities, particular minority communities. And it's not just directed towards black and brown people. You can be, just want to be blunt, you can be a poor white person in a minority neighborhood and you can still be treated the same exact way. So I research those particular areas. And I published in the scholarly journals where they're refereed, and then I also write textbooks. I got into writing textbooks because, again, our students in university cannot pay $210 for a textbook that every semester they're changing a chapter and charging more. So I started writing textbooks on the classes that I teach. So the majority of classes that I teach are policing. So I have a textbook on policing. I have a textbook that I wrote on police use of force. And I have another textbook that I wrote and I'm still field testing, and it's for minorities in the criminal justice system. And the title of that book, there's samples of it online, is Minorities in the Criminal Justice System, not justice, but justice system, where again we look at, actually I lay out the factors. How do we assess a police officer's use of force? What is excessive force? How are police officers trained? Is there a difference between a police officer not following their training, right, and violating someone's rights? And I say we, but the book spells out the assessment, the methodology that's utilized to make those critical assessments.
Were you contacted by the defense in this case to review materials and possibly assist the defense as testifying as a witness in the case?
Yes, sir.
Let's talk about the materials that you received. Did you receive the autopsy report of Mr. Jones?
And just so you're honest, I'm just referring to my list of documents. Yes, I did.
Did you receive Dr. Stephen Nelson's review of the autopsy report?
Yes, I did.
Did you receive Dr. John Thogmartin's review of the report?
Yes, sir.
Did you receive the FBI animation?
Yes, I did.
Did you receive the walkthrough of Mr. Raja?
Yes, sir.
Did you receive the call to Allied Dispatch?
Yes.
Did you receive the 911 call?
Yes, I did.
Did you receive the Palm Beach Gardens Police Department police radio traffic?
Yes, I did.
Did you receive State Attorney's Office Deputy Chief Investigator Mark Anderson's June 1st, 2016 redacted affidavit and certification?
Yes, I did.
Did you receive the expert report of Wilfred Libby?
I received 2 reports from Mr. Libby.
Did you receive the deposition of Mr. Libby?
Yes, I did.
Did you receive photographs that were provided by the state to the defense of what is either called a laser experiment or a light reflectivity experiment?
Yes, I did.
And did you receive photos provided to the defense in connection with the incident location?
Yes, I did.
And what was your assignment? What did we ask you to look at?
Right, so the assignment or the instructions were to review the documents that were provided to me and to conduct any type of research which I thought was relevant to determine whether or not Officer Roger or Mr. Rogers' use of force was reasonable.
And why is reasonable the issue?
Because it's the standards that every police officer is held to since around like 1989 or right after 1989. The standard for any type of police officer's use of force has to be based on something that's called objectively reasonableness. The first year when I started as a police officer, that wasn't the standard. You know, the standard was that a police officer had to use the minimum amount of force, and minimum amount of force sounds reasonable. Like, yeah, we want a police officer to use a minimum amount of force, but however, that is no longer the standard. So so that we have to look at whether or not the officer's use of force or any type of force was objectively reasonable to be consistent with the training and the instructions that police officers receive.
And is the analysis of whether or not a police officer's use of force is objectively reasonable, does it refer to at the time that deadly force was used?
Not just a deadly force. Anytime a police officer uses any degree of force, the assessment of the force takes place right then and there. So in this case, if each time a bullet was discharged, there's an assessment for each one of those bullets. We can care less what he did before, but at the moment when an officer uses any type of force, regardless if it's reasonable force or unreasonable force, well, if it's unreasonable, it has to be at the moment in which they decided to use force. It has to be based on objective factors.
And is one of the factors the perspective of the officer at the moment that he or she used force?
That is the predominant factor, the officer's perspective. And I feel bad, like I'm insulting your intelligence, but I have to say it because it's not what somebody else thought or what we think. It's what the officer thought at that moment. And then we say, is it reasonable for the officer to have thought that? And if it was reasonable for the officer to have thought that, then we say, okay, then we move to the next part of the analysis. But if it's not reasonable that the officer thought something or believed something, then it's not objective. And should I talk about just the difference?
Well, I'll ask you the next question.
Okay.
Okay. You said the first analysis is whether or not it was reasonable. And if it's reasonable, what's the next step?
Right. So in order to get to the second step, was it reasonable for the officer to believe what it is that he believed? And then if it was reasonable for him to believe what it was that he believed, and it doesn't have to be correct. And that's the thing when we go into communities, a lot of people don't understand that it doesn't have to be correct, that it has to be reasonable that the officer believed that their life was in danger. And the example that I give to my students that, a person has a water gun and they point the water gun at the police officer and the police officer takes out his gun. Is the police officer's life in danger? And the answer is no. But was it reasonable for the police officer to believe their life was in danger? So we go through this objective, we look at objective factors as opposed to subjective factors. So it's what the officer knew at that time to support the reasonableness of their belief.
You testified about what the standard is, and what is the basis for that standard?
Right, so the standard for a police officer's use of force throughout the United States as interpreted by the U.S. Department of Justice comes from Graham versus Connor. And it's based on that objectively reasonable officer in a similarly situated situation. Would they have acted in the same way at the moment that they decided to use any degree of force? That's
a United States Supreme Court case?
Yes.
Is there another case that followed that called Tennessee v. Garner?
Yes. And it talks about, again, when an officer can use deadly force.
Would you describe the methodology that you use in reaching a conclusion as to whether or not use of force was objectively reasonable? What factors do you consider?
Right. So I like to consider I call them units of analysis. So the units of analysis start at the moment that the police officer decides that they have to use any degree of force. And we go one by one to determine what is it that the officer believed, what is the officer claiming, and is it reasonable for the officer to have believed that? And then we say, would another officer placed in that same exact position, would they have acted the same way? Then in addition, I say, okay, would a normal citizen, would they have acted the same way if placed in that same situation? So the unit of analysis is that the first one was it reasonable for Officer Raja to believe that Mr. Jones pointed a gun at him? And the answer is yes. Then the second thing is it reasonable for a person that believes they have a gun pointed at them to believe that their life is in danger? And the answer is yes. In addition, within this case, there was another unit of analysis where Officer Raja indicated that not only was there a gun being pointed at him, there was a gun being pointed at him that had a laser. And he was very, very specific as to the model, the type of laser and everything on that. And then notice I didn't say, did the gun have a laser? Was it reasonable to believe that a gun was being pointed at him that had a laser? And the answer is yes. How do I get to yes? I reviewed a video, I believe that the Sheriff's Department conducted, where they went out in a similar situation at nighttime, and they reenacted the situation where they stood there with a gun, and they pointed it, and they took a video. And on the video, you can see the red light flickering, which was consistent with what Officer Rogers said, that there was a laser on the gun. But was there a laser on the gun? No, but was it reasonable for Officer Raja to believe that a gun was being pointed at him? Yes. Was it reasonable for him to believe that a gun was being pointed at him with a laser? The answer is yes. Was it reasonable for him to believe that the gun that was being pointed at him with a laser could kill him? And the answer is yes. Now, the next thing we say, okay, what would a reasonable police officer do if someone is pointing a gun at them? Are there other options that the officer could have engaged in which would have been reasonable? And then you go down the list. Would it have been reasonable for someone that's pointing a gun at you with a laser where you believe they're going to kill you to say, I'm a police officer, don't shoot me? Would it be reasonable for the person to go back into their car to get identification? And the answer is no, that's not reasonable. What would a reasonable officer do in that same exact situation? And it would be to discharge their firearm until there was no longer a perceived threat. Then we say, okay, now if it wasn't Officer Raja, if it was just a plain citizen that was a good Samaritan that pulled over to the side of the road, went down the embankment, and they saw the car, and a person pointed a gun at them, would it be reasonable for that person to believe that they saw a gun? The answer is yes. Would it be reasonable for them to believe that the gun had a laser? The answer would have been yes. Would it be reasonable for them to believe that the gun that was pointed at them that had a laser on them could kill them? The answer is yes. So that's the first part of the analysis dealing with the first three shots.
Okay. Now, do you have an opinion as to whether or not the use of force by Officer Raja in the first three shots was reasonable?
Yes.
And what is that?
It was that Officer Rogers' use of deadly force in connection with the first three shots was objectively reasonable, and a reasonable police officer or just a reasonable citizen placed in a similar situation would have responded in the same exact manner.
And is one of the factors, and I know that you talked about this, but I just want to emphasize it, is one of the factors that video that you saw with the red light flickering off of the barrel of Mr. Jones' gun as being held by a state attorney investigator?
It's a factor, but regardless if there was a laser on the gun or not, it doesn't matter. If Officer Roger reasonably believed that a person was pointing a gun at him, regardless if it had a laser or a flashlight, it doesn't matter what on it. If he believed the gun was being pointed at him, he would have been justified to respond by discharging his firearm until he no longer perceived a threat. And then, which is difficult to understand, that this is what we call a time of the essence situation, where this is a fast-paced situation where the officer has to make a reasonable, take a reasonable action at that time. Meaning that he can't go back to his patrol car. He can't call the friend on the phone and say, hey, listen, this guy's pointing a gun at me. Should I do A, B, or C? This is a fast-moving situation where he had to respond right then and there.
In assessing the reasonableness of Officer Raja's belief, was it a factor when, in your consideration, that he said, I saw red flickering around the barrel of the gun, and you then saw the reenactment showing the red flickering around the barrel of the gun?
Yes, it was a factor.
Now, you said that your opinion is that the first 3 shots were objectively reasonable. Then let's talk about your analysis regarding the second 3 shots.
Right, so the second 3 shots, again, it takes the same exact analysis, but again, police officers are trained in this theory called imminent danger. Imminent danger where a layperson really doesn't understand what an imminent danger is. Most people think, well, if the person is pointing a gun at you, yeah, that's imminent danger. But maybe if the person is not pointing the gun at you, that's not imminent danger. Within this situation, within this case, Officer Raja indicated that Mr. Jones turned and pointed the gun at him again, and then he perceived it again, his life to be in danger, so it would have been reasonable for him again to discharge his firearms those additional 3 times until he perceived that there was no longer a threat. Also, police officers are trained. It's not applicable in this case, but imminent danger does not mean that the person's actually pointing the gun at you at the time. And the example that I do in my classroom is that I have a student walk behind me, and I'm walking away from them with a gun, and then I say, "Is your life in danger?" And everybody in the beginning says, "No." And then when I explain to him what imminent danger means, at any time I can turn around and I can shoot you. So police officers throughout the United States are trained that imminent danger does not mean that a person is pointing a gun at you right at that time. The person, if you notice that the person has that weapon and the person is running from you, right, that person still can be perceived as an imminent threat. But in this case, based on the units of analysis, it was that Mr. Jones turned towards Officer Raja. Officer Raja identified the weapon again, and he discharged his firearm again. And that his use of the firearm was objectively reasonable, and it would be consistent with police practices and procedures and training that officers receive all across this great nation.
You're talking about the methodology that you use. Are there certain things that you do not use?
Yes.
What would one of them be?
Right. So I don't use, or a researcher does not use gut feelings, or they don't use subjective analysis. A researcher and the methodology would be inappropriate to use subjective analysis, gut feelings, or even to assess the credibility of someone. That's not within my area of expertise, to assess someone's credibility. So we look at it from what a reasonable officer would have thought at that particular moment.
So is it appropriate to utilize the subjective assessment of credibility in this type of analysis?
Oh, absolutely not.
Now, do you have an opinion as to whether or not the manner in which an officer approaches someone is an acceptable factor or unit of analysis to assess whether or not the officer's use of force is reasonable?
It's an absolutely flawed factor. It's a ridiculous factor because it deals with tactics. And there's always going to be a better tactic that someone that has the luxury of sitting back, the courts talk about that 20/20 hindsight, where we can say, yeah, this tactic would have been better. Like Columbine. Prior to Columbine, the thing was that you wait till other officers get there before you go in. And then someone says, hey, that was a bad tactic, that the first 3 officers, when they get there, they need to go in immediately and neutralize. So to assess somebody's tactic has nothing to do with whether or not their use of force was reasonable or not.
Why is that?
Because it has nothing to do with it. Where we talk about, if a person should have walked up to the passenger side of the car as opposed to the driver's side of the car. If the person should have had the hat on, not had a hat on. It has nothing to do with, at the moment in which force was used, was it objectively reasonable for the officer to believe that their life was in danger. Has nothing to do with the approach. Has nothing to do with the approach.
Going back to the analysis beginning at the time that the force was used, the assessment of at the time that the force was used, that's the proper way to assess it.
Well, that's the only assessment. I mean, it would be silly to use, because you would go back, because there's no way that an officer can do something perfect, and they're not, and most officers are not perfect. A lot of officers are far from perfect. But to hold a police officer to a higher standard because there's always something better, that's not the assessment, and that's not the assessment from the Department of Justice as interpreted in the Graham decision. It's at the moment that the police officer uses any degree of force, is it objectively reasonable at that time? So the approach has nothing to do with this.
May I have a moment, Your Honor?
Sure.
Last question, or maybe there might be a follow-up, who knows? Is it your opinion that each of the 6 shots fired by Officer Raja was justified?
Yes, that they were objectively reasonable, and a similar police officer or citizen placed in the same situation would have acted the same way.
Thank you.
Cross-examination?
Dr. Chapman, you testified on direct a few minutes ago that you were doing this case pro bono.
Yes, ma'am, and good afternoon.
Did you enter into a retainer agreement with the defense team in this case?
Originally through my consulting company, I did.
Okay, and that retainer agreement was for $3,500, right?
Yes, ma'am.
So you, at the time you gave your deposition, it was not your testimony that you entered this case in a pro bono fashion, correct?
That is correct.
But since your deposition last year or early this year, you decided to take this case on pro bono.
Well, the National Excessive Force Institute, we did, yes.
Okay, so you're not getting a dime.
No, I'm not asking you to pay the money that you owed me, not you, but the city owed me or state owed me for my deposition. The only reason, well, because I sent you a bill, which wasn't paid, and I'm not asking for that. But to answer your question, the only money I receive is for my transportation. Normally, I receive a $600 a day per diem for each day that I'm in court. Plus, normally receive either
wait a minute.
$2,500 per day.
What I'm asking you is, you said in deposition that you were being retained for $3,500. Now, today you're saying...
Oh, that's not what I said.
Do you recall giving a deposition?
Right. I said the retainer in the case was $3,500, and then you asked,
Correct.
does that cover your deposition here today? And I said, no, I sent you a bill for my deposition payment. And then you said, if I recall correctly, no, that's not what I'm asking you. I said, but no, I want my money. Then you said, oh, I'm sorry, I didn't mean that we weren't going to pay you. That's what the deposition says.
Sir,
And then
I'm
we went
simply
through the
asking
hourly rates.
I am asking you, is it your testimony that you are not being paid for anything or any work that you've done on this case?
That's correct.
So that original $3,500 retainer agreement that you testified to in deposition, that is no longer in existence?
That's correct.
I want to talk to you now about your qualifications. You testified during deposition that you are a subject matter expert in several areas, correct?
Yes, ma'am.
And you are you consider yourself a subject matter expert in pre-hospital emergency and emergency communications? Is that right?
Again, I consider myself, but I don't go around giving myself a title. It's either a peer-reviewed organization will identify me as a subject matter expert, or a court will give me the designation of a subject matter expert.
When you gave your deposition, did you consider yourself a subject matter expert in that area?
Yes, ma'am.
Okay, so that is the first area you consider yourself a subject matter expert in, correct?
I have been designated as a subject matter expert, and I agree with that designation, yes.
Okay. And you also consider yourself, or have been designated, a subject matter expert in venipuncture. Is that correct?
Venipuncture specifically for the medical legal analysis of drugs and alcohol, yes.
Okay. And you also consider yourself a subject matter expert, or have been designated as such, in medical/legal blood draws as it relates to DUIs. Is that correct?
That's venipuncture, yes.
Okay. And you also consider yourself a subject matter expert, or have been designated as such, in medical/legal interpretation of blood results. Is that correct?
Yes.
Okay. And you also consider yourself a subject matter expert in the use of force?
Again, I consider myself, but I said it gives the impression, or I want to make sure I understand that it's not just I consider myself an expert, meaning that I went before judges throughout this great nation, both in state courts and federal courts. The Justice Department, the State Department have asked me to conduct either research or training in those particular areas because they designated me or considered me to be a subject matter expert. I agree with those designations.
So you have been declared, and you consider yourself a subject matter expert in several different areas?
Yes, ma'am.
Other than use of force as it relates to police officers, right?
Well, yes.
Now, did you prepare a written report in this case?
No, ma'am.
And you did not prepare a written report in this case because you were not asked to, right?
That's correct.
And you've actually been retained approximately 59 times as a use of force expert. Is that accurate?
Approximately, yes.
And out of those 59 times that you have been retained as a use of force expert, you have been retained once in the area of criminal law, correct? Prior to this case. I mean, it's yes or no.
I'm just not sure how to answer the question without violating any type of confidentiality.
So I'm asking you, have you been retained as a use of force expert in criminal cases before?
Yes.
How many times?
I don't know.
Okay. You recall giving a deposition, and I asked you, out of the 59 cases that you listed, how many of those cases are criminal cases? And your response was 1. Now, does that refresh your memory?
Right, that's a different question.
Then what?
You asked me how many cases were I retained as in a criminal case.
Yes.
Right. And the question that you asked during deposition was, of the 59 cases that are listed here, how many of them were criminal? Mm-hmm. And the answer was 1. They're two different things.
So how many total criminal cases?
Well, there have been times where I've been contacted and I would review the position of a state's attorney or the federal government's position on a criminal matter, and I didn't agree with their theory of the case, so I wouldn't take the case. But yet, because I reviewed certain things, I guess I was like a consulting expert, but not disclosed to the court.
So how many times total have you been retained? Sir, how many times total in a criminal case have you been retained as a use of force expert? You said in deposition 1. Now what are you telling us today?
Right, so I'm telling you the same thing. Of the 59 cases that are listed on the CV that I gave you, there was one criminal case.
Okay. I want to talk to you about some of the things that you spoke about on direct and what you currently do. And you indicated that you actually teach, right?
Yes, ma'am.
And you have authored a textbook on policing. You testified on direct that you've authored a textbook on policing, is that right?
Yes, ma'am.
All right. Now, you consider yourself a use of force expert as well as an expert in generally accepted police practices?
So within several state and federal courts, I've been accepted and recognized as a police use of force expert, as well as policies and procedures.
Okay. So now when we
And
talk
training.
about, okay. Now when we talk about practices, policies, and procedures, when you talk about your textbook, and what I'm referring to now is your textbook on policing, because you indicate on direct that you provide a lot of training and best practices in the use of force, and you've even gone so far as to write this textbook on policing. So within that framework, have you discussed the topic of the manner in which an officer should approach a vehicle, whether they know the risk, and what I mean by that is whether or not they know that the vehicle is occupied or unoccupied?
No, because that's not applicable to a police officer's use of force. The tactics that they use when they're in a to be in a position.
I'm not talking about use of force right now.
I'm talking about, well, I thought you were talking
I asked you
about.
about your textbook on policing.
Right. So no,
and approaches.
right. So the textbook deals with the history of policing within the United States. It deals with police use of force, and it goes through several cases. How do we assess police officers' use of force and other police tactics?
Okay. And you testified that in this case, that you looked at the time in which the defendant fired his first shot. That is your approach for the proper analysis to determine whether or not the shooting was objectively reasonable or justifiable, correct?
I testified that this was a time of the essence situation, so that's one of the factors, yes.
And so when you start to make your assessment in this case as to whether or not the defendant was justified or whether or not what he believed was reasonable, you start from that first shot, right?
No, ma'am.
That's not what you testified to on direct?
If it is, I apologize. What I meant to say, that when an officer uses force, that it has to be objectively reasonable at the moment that they decide to use force. So I think what you're saying, what I interpret, if I'm wrong, correct me, when I interpret your question to mean that after the first shot was fired, that's when I determined as a unit of analysis if it was objectively reasonable. And it's no, and I'm sorry if I gave that impression. It's at the moment the officer believes that it's necessary for them to use force. So obviously they have to receive a message, think about it, and then they have to respond. So when they the situation that they're in, at the moment that they decide to use force, that's when the assessment starts, not after they fired. You have to perceive a threat before you respond to a threat.
Sir, you said on direct that each time a bullet is discharged, your analysis is whether or not at the moment that bullet is discharged, whether or not it was objectively reasonable,
Correct.
right? So, back to what I said a few minutes ago. At the time the defendant fired his first shot, did your assessment include whether or not he perceived a threat?
Oh, yes, I'm sorry if you didn't hear. I went through a complete analysis. I talked about when Officer Raja approached Mr. Jones and Mr. Jones had the gun pointed at him. That was a unit of analysis. Then I talked about the gun where Officer Raja perceived that there was a laser on the gun. I said that was a unit of analysis. I then said that regardless if the gun had a laser or not, it would be reasonable for any police officer, any citizen to believe that if a gun is pointed at them, that their life was in danger. Those were the units of analysis that I went through, ma'am.
So now, you had an opportunity to review the walkthrough in this case, right, of the defendant?
Yes, ma'am.
And you've had an opportunity also to listen to the AT&T open line phone call that was actually recording everything as it was happening in real time, correct?
Yes, ma'am.
And when you listen to that roadside assistance call and you're taking notes or whatever it is you do, does that, what you hear being said from the defendant as well as from Corey Jones, do you take that into account as to whether or not the first shot from Officer Raja, from Defendant Raja, was justifiable or objectively reasonable?
Right. So to do an appropriate analysis of any police.
Do you take that into account?
I can't answer yes or no.
When you listen to the roadside phone call, did you take it into account when you were making your determination or forming your opinion as to whether or not it was objectively reasonable?
I considered it.
You considered it?
Yes.
Okay. And what was it about it that you considered?
Right. So I listened to the walkthrough. I listened to the roadside assistance tape, as well as, and then I compared the two. Like, one, was it reasonable for Officer Raja to believe that a gun was pointed at him? Two, was it reasonable for Officer Raja to believe that if a gun's pointing at him, that his life is in danger? Three, which I considered, but wasn't a major factor because, again, really doesn't matter if the gun had a laser on it or not, but it just kind of goes to that Officer Raja gave specificity about something where he truly, reasonably believed it, but it wasn't actually true.
Okay, but it
And
doesn't
then
matter
three,
whether or not.
no, it doesn't,
doesn't
ma'am.
matter whether or not Officer Raja saw a gun. Would you agree with that?
Like I said before, if Officer Raja reasonably believed he saw a gun, it matters, yes.
Okay. So in order for you to get to the opinion that you have arrived at, that it was objectively reasonable for this defendant to shoot Corey Jones, you believed that Officer Raja saw a gun.
No, I look at all the units of analysis to determine whether or not it's objectively reasonable for Officer Raja to believe that he saw a gun at the time in which he discharged his firearm. And it's objectively reasonable based upon the standards that police officers use or train to. It's based upon all of the literature that police officers and, well, I shouldn't say police officers, but scholars and criminal justice academic utilize, as well as the guidance given from the FBI, the Justice Department. If you think of any scholarly law enforcement organization, I utilize those units of analysis.
When he said during his walkthrough, which you've taken a look at, when he said, and he's going through what happened, when he said that Corey was standing in his doorway and that Corey had the gun like this and it was just above the top of the car, did you believe that? Did you believe Raja saw what he said he saw?
Again, it doesn't matter what I believe, and I do not, it's inappropriate for any police practice expert or any researcher to assess the credibility of any witness. However, if there are units of analysis that are blatantly wrong, that are contradicted by other reliable units of analysis, we consider that. But to determine whether or not any citizen, any police officer believes their life is in danger, it's based on the perspective of the officer at the time without assessing their credibility.
So you sit here and you say that it doesn't matter what you believe, but yet you are sitting in this courtroom and you are offering an opinion based on a walkthrough video that was done by the defendant. Corey Jones wasn't there. So you had to, if you're not assessing his credibility based on the walkthrough and forming your opinion, then what in the heck are you basing your opinion on?
Excellent.
If you're not looking at that.
Sure. So if there was an allegation that that gun was not Corey Jones's gun, Mr. Jones's gun, and the state's position is that Mr. Jones did not have a gun, and now Officer Rogers says that there was a gun, I cannot assess anyone's credibility. But now we can take units of analysis. We can say, one, Officer Rogers said that he saw a gun, which he believed could kill him. He saw a gun that had a laser on it. A gun was found. The units of analysis show that the gun belonged to Mr. Jones. So when you take that, when you take those units of analysis, again, that helps support the opinion that it's reasonable for Officer Raja to believe that the gun that belonged to Mr. Jones was pointed at him. Again, I do not assess someone's credibility. The only time that we're allowed to assess someone's credibility if it is blatantly contradicted by other reliable units of analysis. Any expert or any researcher that assesses someone's credibility are using inappropriate units of analysis.
You said that when you testified on direct, you said that Mr. Richardson asked you about all 6 shots. And you said that all 6 shots were justified. That all 6 shots were objectively reasonable based on what the defendant, believed. Now, in order for you to provide that opinion, you yourself have to make an assessment as to the credibility of what that defendant is saying as it relates to his walkthrough and what he said transpired, correct?
No, ma'am. If you look at any of the federal guidance that is given to researchers, we do not assess the credibility of a witness. If we look at the guidance that courts have given researchers or experts about assessing someone's credibility is a judge's job or a jury's job. It's not my job to assess someone's credibility. What my job is to determine when a person says something, to look at the available units of analysis and say, okay, is it reasonable for the person to believe that? As to if he's lying or not, that's outside of my scope and it would be inappropriate for me to attempt to assess his credibility.
But based on what you heard in the walkthrough, you found it to be objectively reasonable because of what he said, correct?
Based on all of the units, should I repeat it again? Sure. Based upon all of the units of analysis within this case, when you assess the use of force of an officer or a citizen, it's based on the perception of the officer at the time. I believe on direct, I said specifically, I give an example to my classes where people have a confusion, maybe like this. If a person has a water gun and they're pointing at a police officer, is it reasonable for the officer to believe that their life is in danger? Right? I can't assess whether or not the officer believes his life is in danger, but I can say if the officer does not know that that's a water gun and someone's pointing a gun at them, and even though it's a water gun but it's a real gun, or if it looks like a real gun but it's a water gun, it's reasonable for them to believe that their life is in danger. Their life does not have to be in danger. It just has to be reasonable for them to believe. And now we say, okay, well, how do we get to determine whether or not, what is the methodology that's accepted for criminologists, for researchers to determine what a reasonable person or what a reasonable officer would do? Then we look at the standards. And then I went through those standards.
And based on those standards, based on what you heard in the walkthrough, you provided an opinion, right?
Yes, ma'am, I provided an opinion.
Yeah, and
Yes.
that opinion was based on everything that you reviewed in this case.
Right, the totality of the case, correct.
Right?
Yes,
Which
ma'am.
included the walkthrough.
Yes, ma'am.
And you said, you give an example to your class or to your students about, if someone is pointing a gun at an officer, it can be a water gun. But if the officer believes that it's a gun and the officer fires, then it's objectively reasonable for that officer to fire back. That's your testimony, right?
No, ma'am, that's not what I said. I said if the officer reasonably believes. See, there's a difference between someone just saying, oh, I believe this, or I think that. That's not objectively reasonable. Objectively reasonable is there's a methodology to come up with objectively reasonable based on based on the question that you're trying to answer. So if I said that if that's what you heard, I apologize. What I said was that I tell my students, if a person is pointing a water gun at a police officer, and the police officer reasonably believes that that water gun is a real gun and their life is in danger, then they would be allowed to use deadly force.
Okay. And you accept the premise that there was a gun pointed at the officer in order for you to make the next step and provide an opinion or opine that it was objectively reasonable.
Now, so the first step is whether or not it was reasonable for Officer Raja to believe that a gun was pointed at him. And then once you have that unit of analysis and you say, was it reasonable? Yes. Then you go to the next step. Okay. Was it reasonable for officer?
So that's why I want to stop you, because we already know, and I'm not going to go through this ad nauseum with you, because in your opinion, you've already said that in order for you to reach the opinion that you have reached, you have to you've looked at everything in this case, in which case that means that you've looked at the walkthrough, you've looked at the 6 shots, and you found that it was objectively reasonable for the defendant to believe that he saw a gun. So now what I want to do is, Judge, at this point, I'd like to cue up an excerpt of the open line call, please.
Okay. Well, I think while you do that, we should all maybe take a break so you can cue it up. Does that sound good for everybody? Okay. So we're going to take about a 10-minute break. I'll be back here at 5:05. Okay, everybody? Okay. Thank you so much. All right. As I said, the state's here, defense is here, defendant is here. And, sir, Dr. Chapman, you're back on the stand under oath, sir.
Yes, ma'am.
Did you want to wait for Mr. Fernandez, Ms. Ellis?
Judge, he may be in the restroom. We can get started because I'm going to go ahead and play the call. Here he is now.
Okay. All right. Do we have it queued up?
Yes, Judge.
Okay.
You ready? Yes.
Thank you for calling AT&T Roadside Assistance. This is Patty. May I have your mobile number to better assist you?
561-573-2815.
Okay, give me one moment to pull up the account.
For the record, it's Exhibit 3, correct?
Yes, Judge.
Okay.
It is.
And what's the name on it?
Corey Jones.
Okay.
Housing.
Yeah, I see Delray Beach House.
Yes.
All right. And what can I do for you tonight?
I need to get a tow. I'm
Okay.
broke down.
And is this mobile number with the vehicle?
Yes.
Okay. What's wrong with the vehicle?
It won't start.
Okay. And is it a 4-wheel drive?
I think it's 2 wheels.
What's the address of the vehicle location?
I'm off the PGA downtown exit on 95.
On 95?
I-95 exit PGA southbound.
Okay, is there any, hold on, let me write southbound down. Is there any buildings, landmarks, anything like that, that I could use to pinpoint your address?
Stop. I'm good. Yeah, I'm good. Yeah.
So now, you've listened to that before, today, right?
Yes, ma'am.
Now, the first thing that, among the first thing that we hear Officer Raja say is, get your effing hands up, get your effing hands up, get your effing hands up. Correct?
That was one of the first things, yes.
You hear Corey say, yeah, I'm good, I'm good. And then you hear the defendant escalate it to really, then get your effing hands up. Now, the 3 times in which you hear him say, get your effing hands up, get your effing hands up, get your effing hands up, what is that indicative of to you?
That Officer Raja perceived a more than minimum threat or risk, so he was trying to get his message across as quickly and as surely as possible.
Okay, so when an officer tells a person, get your effing hands up, I mean, logic, pure logic and common sense tells us that they don't see the person's hands, right?
I don't want to go there about logic and common sense, but it's reasonable to believe that Officer Raja did not see his hands.
Okay, so he did not see his hands, but yet during his walkthrough, which you've seen also, right? He says, I gave him commands and I told him to drop the gun. I told him to drop the gun. I remember screaming, drop the gun. As a matter of fact, in his walkthrough, 7 times, he says, I gave the command, drop the gun. So if the threat, you as the expert here, if your assessment begins at the first shot, how is it that the threat to the defendant is there when he can't even see his hands? He's asking to see his hands.
Again, nothing of what you said is what I testified to.
I
went over. I know, but you just said that I said something.
I'm asking you a question. I don't care what you testified to. I'm asking you the question.
Right, but the question has to be based. I believe you said that I said that the assessment starts when he discharged his firearm.
You said.
That's not what I said.
You need us to play your testimony back for you. You said that when you conduct your analysis, okay, an objective analysis to whether or not the officer perceived the threat and fired his weapon, was that at the time the weapon was fired, was it objectively reasonable? And then you talked about these units. You recall that?
Ma'am, you're almost there. What I said was that the assessment starts at the moment the officer perceives that their life is in danger.
Correct.
So when they perceive their life is in danger is before they discharge. Maybe that's the confusing. You have to perceive something, you take it into your mind, you perceive it, you process it, and then you respond to what you perceived. And then instead of saying perceived, I said, was it reasonable for Officer Raja to believe that his life was in danger? Then I went through the analysis, talked about the individual units of analysis, about the gun pointed at him, the gun with the laser, and then I went through that.
So if Officer Raja can't see his hands, then how is he perceiving a threat?
Excellent question. I think you're confusing the time and space. When you take things out of order, right, if at one point, any officer in this great nation will tell you that the first thing you want to see is the person's hands. If you cannot see the person's hands, the heightened threat rises. It rises because the very same people that police officers are supposed to defend sometimes kill police officers.
Okay.
So it's reasonable for Officer Raja to want to see his effing hands during this time life critical event. Once I'm answering your question. If you want to just make statements and not let me answer, I'm fine with that. The second part of your question was, if he couldn't see his hands, how could he see the gun in his hand? There's a point where he does not see his hands. Officer Roger tells Mr. Jones, let me see your hands, or let me see your effing hands, because of the time life critical event. Thereafter, Officer Roger asserts that he saw a gun, not just a gun. He was very, very specific as to the gun, the model of the gun that had the laser on it. I went through all of those things. So for you to pick little things, I mean, there's not a jury. The judge knows. I'm very, very clear when I speak.
And I'm pretty clear when I speak also. Okay? And what I'm asking you here is that when you compare the open line that this defendant did not know was actually open and recording the events as they were going down, when you compare that to what Officer Raja said in his walkthrough, where he says, he jumped out, I jumped out. The first thing he did was pointed a gun at me. He doesn't say anything throughout the entirety of his walkthrough. He says nothing about, I said to him, let me see your hands. He never said that once during his walkthrough, did he?
I did not hear it, no.
Okay, so that's not the truth then. The defendant didn't tell the truth.
No. Well, I'm not saying no, he did not tell the truth. I'm saying no, one, I don't want to say it's an inappropriate question, but it's an inappropriate question to ask a researcher, because I told you over and over that we don't assess a person's credibility. And then during deposition, I thought I was crystal clear when I told you that simply because an officer may say something that's later not 100% true does not mean that they had an intent. Remember, I went through mens res and actus reus, having a guilty mind, knowing what you're saying. And the perfect example that I gave you during the deposition, again, ma'am, is the laser on the gun. We can say that Officer Raja lied about seeing a laser on the gun because there was no laser. So he lied, right? But did he have the mens res? Did he know that he was lying? Or was it reasonable for him to believe that there was a laser on a gun that was pointed at him that could shoot and kill him? So I don't classify that as a lie. It's that he perceived something.
You just heard the open line call again, and you heard you heard the defendant clear 3 times. Each time it got louder. Show me your effing hands. Show me your effing hands. Show me your effing hands. Now, one time did we hear drop the gun. Now, he said that 7 times. So now it is your assessment that that was not a lie when he completely omitted saying that I told Corey to show me his hands, but he emphatically and repeatedly said in his walkthrough, I kept telling him to drop his gun. So you're choosing to look at that as just, he didn't have the mens rea, he didn't have the intent, rather than choosing to look at that as a lie. So you are assessing credibility, sir. Whether you want to sit here and admit it or not, you are assessing credibility.
I'm not sure if that's a question.
No, it's not a question.
Okay.
Because that's what you did.
Oh, okay, all right. Ask a question, please, Ms. Ellis.
I apologize, Judge. You continue to try and prove your or support your opinion that what Officer Raja said in his walkthrough was true, and then you go to the fact that he even talked about a gun and that it was a laser, and that he thought that the gun had a laser on it. And in your mind, that was something that you thought was relevant because it lent itself to Officer Raja's walkthrough being credible, correct?
Again, I don't mind answering again. I do not assess an individual's credibility. No trustworthy, reliable expert will attempt to assess someone's credibility unless there's something that's blatantly wrong or a lie that's contradicted by other reliable, relevant units of analysis. The two parts to your question, and I'll answer the second part first about the laser, that the laser on the gun is a perfect example of when we say we have to assess what the officer reasonably believed. The officer doesn't have to be right. The officer has to reasonably believe that their life is in danger. So was it reasonable for Officer Raja to believe that the gun that was pointed at him had a laser on it? Is it objectively reasonable? And then we look at the other factors that support that, right? The sheriff's department went out. They pointed a gun. They took a video, they took pictures, and they said, hey, this is where Officer Raja said he was standing, and we see the blinking light that Officer Raja said he saw. So it's not what a reasonable officer reasonably believed that they saw it. Other reasonable officers saw it. Other reasonable officers saw it. Now, to the first part of your question, I do not assess a person's credibility. Researchers do not assess individuals' credibility.
Sir, that is absolutely ludicrous, because you have given an opinion in this case. And your opinion in this case is that all 6 of those shots were objectively reasonable. So you're telling us today that you have not assessed whether or not that walkthrough that that defendant gave on that date, almost 4 hours after he shot and killed Corey Jones, you're telling us that you have not made an assessment about his credibility, but you're sitting up here today and telling us that all 6 shots were justifiable?
Ma'am, I told you that a police officer placed in Officer Rogers' position would have reasonably believed that their life was in danger when a gun was pointed at them, a gun with a laser on it. It would have been reasonable for the officer to discharge their firearm 3 times. And then, if Mr. Jones turned and pointed towards Officer Raja again with the gun, it would be reasonable for Officer Raja to discharge his firearm again. Simply because you don't like the answer that I'm giving you, this is the best answer. And anyone that tells you that they can assess or tell you read someone's mind or tell you that someone lied or tell you that the person purposely lied, they have no basis for that, for any such opinion. It's a guess. It's a hunch. Remember I talked about on direct objective factors versus subjective factors? Someone that's assessing someone's credibility are using subjective factors where it's a net opinion. They're not connecting it to anything. It's just a hunch.
Sir, when he says that, when Officer Raja says that I said drop the gun, I remember screaming, drop the gun, drop the gun. When he was running and I was going after him, I was yelling. I was like, drop the gun, I'm gonna fucking kill you, drop the gun, yelling at the top of my lungs. When he says this over and over and over again, and you compare that to the open line call, is it your testimony here that you have not made an assessment on credibility about this defendant as to whether or not he was being truthful or not?
Ma'am, when you assess an officer's use of force, it's based on the units of analysis which an objectively reasonable officer would have believed at the moment they decided to use force.
So what
I
do you
can
believe?
care less.
What do you believe?
I cannot read
But what do you
Officer
believe?
Reiser's
My question
mind.
is to you.
I do not have
you
this.
believe,
I'm sorry,
sir?
ma'am.
What
I
do
do
you
not
believe?
have the skill sets
What
to,
do you believe?
to,
What
to
do
read
you
someone.
believe? That's my question to you. What do you believe
About what?
about whether or not the defendant saw a gun being pointed at him?
Oh, I believe it's reasonable for Officer Roger to believe that Mr. Jones pointed a gun at him and that Officer Roger reasonably believed that there was a laser on the gun and that Officer Roger reasonably believed that if he did not use deadly force that he would have been killed. That's what I reasonably believe.
And that is not a credibility assessment on your part?
No, ma'am, it's not.
Okay. Now, you also talked about this light, and I go back to this light that you said supports what the defendant said about the red laser on the gun, showing this to defense. I'm going to show this to you as, Judge, this is going to be marked just as an exhibit for States 1.
Okay.
Just take a look at that picture. Have you seen that picture before? In the materials that you were provided?
I've seen several
seen
of the.
that one?
I can't tell you exactly, but I've seen pictures similar to this as well as the video.
Okay, so now what are we looking at on that picture right there?
It looks like there's a red dot here on the barrel of the gun, the laser.
What color is this? I want you to look at this gun. I want you to show the judge what you see here. What color is there?
So the traffic, we know now that the traffic light behind. So here, we see the color green, and up here, I see the color red. But again, that's what I see.
So you see green, and it's your position that you see red also.
Yes, ma'am.
So if you looked at this photograph during your assessment, then you would also know that it's possible that just like that light, that red light, was reflecting off of the chrome gun, those photographs that we have that you've reviewed, that you talked about on direct, then you would have had to seen this photograph as well, correct? And you would have made an assessment that just as plausible as it is for him to have seen what he is characterizing as a red light that he thought was a laser, it is just as plausible for him to have seen a green light, which is shown on this same chrome gun, right?
That's absolutely 100% an inappropriate analysis. The analysis has to be done from Officer Rogers' perspective, not what someone does later on. So if you go out and you put a green light there and then there's a red light blinking, that's not what Officer Rogers said that he saw. The analysis, the assessment has to be based on the officer there. Officer Rogers said that he saw a red light blinking on the gun. And then the assessment is, was it reasonable for him to believe that there was a red light on the gun? Simply because I saw photos where there were no lights on it. But simply because you pull a photo that has red and green or a photo that has none has no basis as to whether or not Officer Roger reasonably believed that he saw a red light on the gun. The photo that I saw, the video that I saw, when I personally went out to the scene, it was reasonable to believe that Officer Roger reasonably believed that there was a gun that was pointing at him, that had a laser on him, that was capable of killing him.
Okay, and again, these are, you are making an assessment.
Say credibility.
Yeah.
No, ma'am, it's not.
Now, this discussion that we're having here, we're talking about a reasonable officer, right? Not a reasonable person.
The standard will be one and the same. If Officer Roger was Private Citizen Smith that walked up to a person or a person walked up to them pointing at a gun, pointing a gun at them, if Citizen Smith believed that the person had a gun and that gun was capable of killing them, it would be reasonable for Citizen Smith to defend themselves. So it's not just Officer Roger. It would be Mr. Roger or any other citizen in this free country.
Okay, so now, we know that we have what was not truthful, which is defendant saying that he saw a gun. He kept saying, drop the gun, drop the gun, drop the gun. He said that about 7 times. He even said it when he called 911. We know that that's not true, right? Because we listened to the open line, we didn't hear it.
I'm getting confused when you're making statements or asking me a question because we do not know that it's not truthful that Officer Roger didn't see a gun. You know, it's reasonable. That's what you said in the beginning.
What I ask you is, what we know is that listening to the open line, we know we did not hear the defendant say, drop the gun, drop the gun, drop the
Yeah,
gun.
that's not what you said. You have a tendency of putting multiple questions together and then asking me to answer the last one where it gives an improper inference. I think it'd be more productive, just ask one question, I'll answer it, and then we'll do it that way. Because when
If
you
would
lump,
answer
when you
the one
lump them
question that I'm
together,
asking?
it's
Okay.
confusing.
All right. Ms. Ellis will ask the questions. If there's an objection, the defense can object, okay?
Yes,
Just try to answer the questions the best you can, okay, sir? Okay.
So now that we know that we didn't hear drop the gun, correct? In the open line.
Correct.
And what we heard was, show me your effing hands, correct?
Yes, ma'am.
And after that, we heard Raja in his walkthrough tell in a sworn statement that while he was pursuing Corey, that he was on the phone with 911 dispatch the entire time, correct?
I remember hearing that, yes.
Okay. And that was not true either, correct?
Again, it was not correct. As when I answer something not being true, meaning that it's a lie and a person knew it was a lie, and I cannot assess his credibility as to whether or not he believed what he said.
Okay, so he said that he was not on the phone with the 911 operator during this entire incident,
That's correct.
right? As a matter of fact, he didn't call 911 until about 33 seconds after he fired off his last shot, correct?
I don't know that, ma'am.
Okay, so you don't know how long it took him to call 911 from the time he fired his sixth shot?
No, ma'am.
You didn't review that material?
No, my assessment from the point where he perceived that his life was in danger until he used deadly force. Anything that happens afterwards has no bearing as to whether or not when an officer uses force or a citizen uses force, if it's reasonable or not.
Okay. Now, what I want to do is go back to the approach, and you said that you didn't consider anything about the approach in your assessment.
What I said was that the approach doesn't matter. It doesn't matter how he got there.
Doesn't matter how he got there. He could have jumped, skipped, walked, doesn't matter how he got there.
Correct. He could have walked up with his left foot followed by his right foot followed by his left foot. He could have walked backwards. The assessment starts when we say, was it reasonable for him to believe that his life was in danger? The tactic that he used to get into that position has no bearing on the assessment as to whether or not an officer used reasonable force.
And when you talk about generally accepted police practices and best practices, the approach doesn't matter.
So,
How you approach a vehicle doesn't matter.
again, it depends on the situation, ma'am.
But in this case, it didn't depend on the situation.
No, in this case, it didn't depend on the situation.
And it didn't matter to you that he was not dressed in anything that would identify himself as a law enforcement officer, correct?
Correct. That has no bearing as to whether or not it was reasonable for Officer Raja to believe that his life is in danger. And if it wasn't Officer Raja, but Mr. Raja, it would have no bearing as to whether or not he reasonably believed his life was in danger or not.
And it didn't matter to you that he had a tactical vest and he had all of his gear right there in his van. That didn't factor into your consideration as well, right?
Right. When you're assessing a police officer's use of force, those tactical ancillary things do not get to the question as to whether or not the force was reasonable or not.
Okay. Now, at the moment that he says he jumped out of the car because he saw Corey jump out of the car, that would be considered a generally accepted best practice for policing when you're approaching a vehicle, whether you know it's abandoned or not, correct?
I'm sorry, can you repeat the question?
At the point he says that he jumped out of the car, that he jumped out of his van because Corey jumped out of his car, that would not be a generally accepted practice or a best practice for policing.
Oh, of course.
Approaching a vehicle.
Of course it would. Absolutely.
For him to jump out of his van, for him to pull up to the car in front of Corey's car the way he did, perpendicular to Corey's car, jump out of the van because he sees Corey jump out of his car. You're saying that that is a generally accepted best police practice?
Any competently trained police officer that has someone approaching them is going to get out of their car, regardless if you're in New Jersey, New York, Florida, California. That is the best practice. You are not going to stay within your vehicle.
So, and you just said if a person is approaching the vehicle.
Either or.
So we know that Corey was not approaching his vehicle.
I said
correct?
either or. If a person gets out of the vehicle the police officer is not going to stay in their vehicle. That would be, and again, I would say that's not the best tactic. If an officer decided to stay in the car, I wouldn't fault him for that, because there's always good, better, and best. So we have to look at, was it reasonable? Was it reasonable for Officer Raja to get out of the car when Mr. Jones got out of the car? And the answer is yes.
The answer is yes, that it was reasonable for him. So I take it that your answer is yes, that it was reasonable for him to pull up in front of Corey's car the way he did. That was reasonable also.
Yeah, I have done that numerous times. I've
And
seen
is that
officers
generally
do that
accepted best
numerous
practice?
times. I'm sorry?
Is that a generally accepted best police practice?
Again, it's an accepted police practice. You can have good, great, better, super. It's within the realm of a reasonable police practice.
When Corey opened his door, when Roger pulled up, is it a generally accepted best police practice for Roger to pop out of his vehicle without any tactical vest, radio, anything identifying himself as a police officer?
Right. So in time of the essence situations where you don't perceive someone in the vehicle and a person pops out, we call that a fast-moving situation where the officer may not make the best judgment. If I were in that situation, I believe majority of police officers or 3 or more similarly situated officers could disagree. I am not going to take the time to get a vest, to get a radio, to get any of those things, because police officers know, like I said before, that there's no such thing as a low-risk encounter. All police encounters have risk, and then there is greater risk. If you're approaching a vehicle, when Officer Rogers approaching the vehicle, which was abandoned on the side of the road, and he didn't believe anyone was in the vehicle, when Mr. Jones popped out of the vehicle, again, that caused him, a reasonable officer, to have a heightened awareness, right? And the officer is not, it's the time of the essence. It's a time of the essence. It's reasonable for the officer to say, if this guy is coming out of the gun with a gun or some type of weapon to do me harm, it would be objectively unreasonable for me to go back into my car, to put my hat on, to put my vest on. That would be objectively unreasonable, and I would say that officer was not properly trained.
Or wouldn't it be objectively reasonable for him to pull up behind the vehicle and not pull in perpendicular to the vehicle?
This is a hypothetical question because we know that what Officer Raja testified his intent to do. He wasn't able to finish his maneuver. But it doesn't matter if he pulled up in front, to the side, or to the back. It's at what point, if any, that Officer Raja reasonably believed that his life was in danger. It doesn't matter if Officer Raja was on a Segway and got up there, or on rollerblades. However, once he was in a position, was it reasonable for him to believe that his life was in danger, and did he respond as a similarly situated officer would?
And it's your testimony that it would have been unreasonable for the defendant to put on his vest before he exited his vehicle, once
Absolutely.
he saw Corey's door open.
Absolutely. This is a time of the essence situation where an officer has to make a decision just like that.
Well, what is of the essence? Corey opens the door. There is no evidence whatsoever that Corey even left his doorway other than to run away from his car. So what is of the essence? The defendant himself said that he stood in his doorway. So what is the exigency that causes him, Raja, to believe that he doesn't have time when he sees Corey's door open, to believe that he has no time to put on a tactical vest, something that would identify himself as a police officer, particularly when he's driving around in a white van with nothing written on it?
Ma'am, it doesn't matter if he was a police officer or a private citizen. If a person is pointing a gun at you, you have to respond instantaneously. It's time of the essence. In this situation, Officer Raja believes that he was investigating an abandoned vehicle, a vehicle that had no one in it. And then all of a sudden, somebody got out of the car. He had to make a decision right then and there. It was reasonable for him to say, I'm not going to take the time to go back into my vehicle, to put on my vest or anything else.
Sir, in order for us to get to that quantum leap that you're making, we have to believe that the defendant saw Corey with a gun.
No, ma'am, no,
Is
we
that
don't.
accurate?
No, it's not. Absolutely.
You don't have to believe before you can determine whether or not his use of force was objectively reasonable. You don't have to adopt what he's saying. You don't have to believe that he said he saw a gun.
Ma'am, we were talking about whether or not he should put his vest on. That was the question. I thought you were asking me, what was the time of the essence which
I
required
asked you that
him?
question because you said that time was of the essence, so he didn't need to put the vest on.
Correct.
Okay.
And I want to answer that now.
Go ahead.
Right. So, every police officer, basic police training, there are two levels of threat or risk. There's risk and high risk. There's no such thing as a low risk encounter. Like I said before, every time a police officer approaches someone or someone approaches them, there's that strong possibility that that person has the advantage of knowing that they're going to attempt to take that police officer's life. So the police officer, number one, is not going to be trapped in their vehicle. Number two, the police officer wants to see the person's hands because the hands are what's going to kill them. That the person may have something in their hands. If you see a person getting out of a car, it's time of the essence. You're in your car. You can't move. A reasonable police officer would have
with his tactical vest. He's in his van with his radio. He's in his van with every single piece of tool that he needs in order to make this encounter. There is no evidence. When you listen to the walkthrough, you never heard the defendant say that Corey came from around his door and started approaching his van. What did you hear in his walkthrough? What you heard the defendant say in his walkthrough was that he came around the front of his van. After Corey says, yeah, I'm good, the defendant claims he said, hey man, police, everything okay? So why would someone, if you want to call this, you want to say that he didn't have the time to do this, but he's got enough time to exit the van, walk around the front, listen to Corey tell him, I'm good, everything okay, wouldn't the best practice have been for him either to not get out of the van at all once he saw somebody there, or to put his vest on and get out of the car, or to not put himself in that fatal funnel position where he's right there, where he claims he was, in front of Corey's car? You don't understand that question either.
Man, he had a lot of questions there.
Sir, you're saying, you continue to say that the defendant had no time, that there was an exigent circumstance. My simple question to you is, what was so exigent that the defendant did not have time to put his vest on so that Corey there was something that Corey would be able to see that would identify him as a police officer?
Can you answer that question? Are you able to answer that question?
I'll answer the second part. The exigent circumstances that, again, every police encounter with a citizen, regardless if a police officer is approaching a citizen or a citizen is approaching a police officer, there is a risk and there's a great risk.
Okay, approach, please. Everybody, please approach.
Your Honor, by stipulation, the defense offers into evidence exhibit number 8.
What is it?
It's the video of the light reflectivity test performed a couple of weeks after the incident.
Okay. Exhibit 8 comes in by stipulation, the light reflectivity test.
I'd like to publish it now.
Sure. Is it ready? Okay.
Anticipated without trying to get us done. This video.
Live?
Yeah. turn it sideways. A little bit.
Are we videoing? There's the red light. I'm pointing at the red light right now.
When you swept up toward it,
Huh?
yeah, as you're sweeping toward it, you're glinting off right there. Down?
Now it's green.
Yeah.
Now it's getting red again.
Down? Right. Yeah, you passed it. Go up. Right there. You just passed it.
No,
Right there. Let me get a still shot.
Okay. Mr. Richardson, do you have any questions?
Couple. Dr. Chapman, is that the video that you watched when, the video that you saw that we
Ye-
presented to you earlier?
Yes, sir.
And you saw the red light glinting off of the barrel of the gun that State Attorney Investigator Thomas Wills was holding, correct?
Yes, sir.
And you have actually heard the crime scene investigator who was doing the video saying it's glinting off or it's flickering off, one of those two words, right?
Yes, sir.
And when you heard the audio of the AT&T roadside assistance call, you heard Officer Raja say, "Drop." You heard the word "drop."
I believe I did.
Okay. All right, sir, you can step down.
Thank you.
Okay, so it's right before 6 o'clock, ladies and gentlemen. We are going to start tomorrow at 8:30. We're still hopefully going to finish tomorrow. We set aside 2 days. I appreciate everybody being here today. I appreciate everyone's decorum. I know it's been a long day. I appreciate all of the parties' hard work, and we'll see you back here tomorrow at 8:30, okay? Thank you so much.